Good afternoon. We made it through the heat. Welcome again to Charleston, West Virginia's historic McFarland Hubbard House, headquarters of the West Virginia Humanities Council, the official state affiliate of the National Endowment for the Humanities. And welcome also to the final event in the 2024 Little Lectures Speaker Series, which this year is funded in part by United We Stand, a special initiative of the National Endowment for the Humanities in support of programs that encourage civic engagement, social cohesion, and cross-cultural understanding. We've been very glad and grateful to offer this special series this year, and particularly glad to see so many of our friends, many of you for the full run of the series. So thank you so much for coming out. As always, I want to express my gratitude to the West Virginia Humanities Council's excellent staff, all of whom work to make these events come together, and especially to Program Officer Kyle Wormack, who's curated this speaker series since 2020. Yes, yes. That's the spirit. We're very pleased this afternoon to welcome Professor Robert Miller, who is Jonathan and Wendy Rose Professor of Law at the Sandra Day O'Connor College of Law at Arizona State University. Professor Miller joins us today to discuss the Doctrine of Discovery, an international legal principle that, while still in use today, dates from the late 15th century and was critical in establishing the statutory groundwork for Spanish conquest of the New World. Professor Miller's legal and scholarly credits make for extensive reading, as well as offering a unique critical perspective on legal issues specific to Indigenous communities. A graduate of Eastern Oregon University and the Lewis and Clark Law School, he practiced Indian law with the firm of Hobbs, Strauss, Dean, and Walker, which provides Indian and Alaska Native tribes and tribal organizations with legal services and advocacy. From 1999 to 2013, he was a faculty member at the Lewis and Clark Law School. An enrolled citizen of the Eastern Shawnee Tribe, Professor Miller is Chief Justice of the Pasquayaqui Tribe Court of Appeals. And in Arizona State, he also serves as faculty director of the Rosette LLP American Indian Economic Development Program. He's a noted scholarly speaker and writer on federal Indian law issues. His publications include, among many others, Native America Discovered and Conquered, Thomas Jefferson, Lewis and Clark, and Manifest Destiny, and Reservation Capitalism, Economic Development in Indian Country. He was elected to the American Law Institute in 2012 and to the American Philosophical Society in 2014, where he works as a consultant on tribal language and archival issues. Thank you all for coming, and please join me in welcoming to the lectern Professor Robert Miller. Let's go.
Thank you, Eric, and thank you, Kyle, and everyone else that was involved with inviting me here. I'm delighted to be here. My wife and I were debating if we've ever been in West Virginia before, but I saw the poster on the back wall that John Brown and Harper's Ferry was in West Virginia, so I have been here before. So we're not total newbies. So what else was I going to say? This is the final event, so this proves the old canard that they saved the best for last. And I can stay in this jacket for about that long because I use a lot of energy and I get kind of excited. And yes, I've been writing on this topic forever, and I have the Pacific Northwest, and you're thinking, what do we care about the Pacific Northwest? So I'm going to apply this legal principle that Eric just mentioned, international law of colonialism, and today we call it the Doctrine of Discovery because of an 1832 Supreme Court case by Chief Justice John Marshall. The United States Supreme Court and the federal judiciary adopted this international law principle, what's the old saying, tooth and nail? No, that's not, wholesale. And we still apply the Doctrine of Discovery to Indian nations today. And I've written multiple articles about how Portugal, I'll show you some maps in a moment, and we'll understand why is Brazil, why was it colonized by the Portuguese? Why do they speak Portuguese still there today? Why was the rest of the New World Spanish territory, as Eric just mentioned, and Spanish was the language for, and still is in many of these countries. But I'm going to try to apply this as much to West Virginia as I possibly can. And I've been told that Lord Dunsmore is someone of significance. And I heard about it about a month ago from Kyle. So I am now an expert on this subject. What I know about that scallywag is that he killed my people. And he was out there in the old frontier, we call it, the old Northwest. My wife and I live in the Pacific Northwest, but the old Northwest is today the 5 states of Ohio, Illinois, Indiana, Wisconsin, and Minnesota, I believe. And that's where my people were from from Ohio and western Pennsylvania. And I guess Dunsmore was out there killing us because we didn't like Americans coming and colonizing us. Or I guess at that time it was English, right? So we're talking about an international law because all the European colonizers in the world used this law. I literally published an article 2 years ago in the Duke International Law Journal about how England and Germany used this doctrine of discovery in the 1800s, the late 1800s, to colonize Eastern Africa. Kenya, Tanzania, and Uganda were colonized by England and Germany using the very principles from the 1400s that we're going to talk about today. Now, I can't help but say, why did we plant our flag on the moon? Were we claiming the moon as American territory? Why did Lewis and Clark, headed to where I live in Oregon, why'd they carry a branding iron and start branding things once they crossed the Rocky Mountains? Why'd they leave something that's called the Fort Clatsop Memorial? If you know where Lewis and Clark built Fort Clatsop at the mouth of the Columbia River, because President Jefferson ordered them to do that. Jefferson was an attorney. He knew, I'm getting ahead of myself, way ahead of myself, because you're going, why is he talking about Jefferson? Well, I have 2 hours, right? This event goes till 4, right? I need all that time. So I mentioned that the United States Supreme Court, first Indian law opinion written by Chief Justice John Marshall. He wrote the 3 probably most important Indian law cases. We call them today the Marshall Trilogy. And when you teach an Indian law class, you start with these 3 cases. Now you're looking, I know you're desperately looking, trying to read, well, which one? Is the plaintiff an Indian or is the defendant an Indian? I hear a couple little jokes already. Well, there's no Indian involved in this case at all. No tribal person, no tribal nation was allowed to defend tribal rights in this case. This was 2 Americans arguing over land that's now in the state of Illinois, who owned it. Mr. Johnson had inherited shares from his grandfather in a company that allegedly bought land from chiefs out in the woods of what's now Illinois, had signed deeds with the native people putting their thumbprints on it as a signature. And so they claimed they owned it from purchases made in 1773 and 1775. Now, I emphasize those dates because that's before there was any United States. This case, although it's 50 years later, is about what legal right did Englishmen have to buy land from Indian peoples under the international law that today we call the Doctrine of Discovery. Now, it takes 50 years for the case to bubble up into, oh my God, this company was bribing people left and right. They bribed Benjamin Franklin. They bribed several Virginia people to try to support the company. They wanted this land ownership. Mr. McIntosh, however, purchased the land in 1818 from the United States, who had signed a treaty with the Piankashaw and Illinois tribal peoples. The United States claimed it had the land ownership and could then sell it to Mr. McIntosh. So it's a classic case, who owns the property between 2 Americans now, but it's based on international law. What does the case hold? And this is where we get the word, the title, Doctrine of Discovery. The word discovery is in this opinion 30 times, only twice as a verb. So I'm no English major either, so I guess that means he used the word as a noun. And he was describing a legal principle of how Europeans claimed land around the world and then how they justified it. He says this country, and remember, this case is really about British law, because what were the land purchases made by Johnson's grandfather and the corporation that he created to do this? Were they legal purchases? And this was when they were British citizens. And at the end of this talk, I'm going to tie this back to West Virginia very distinctly and the Royal Proclamation of 1763, in which King George III plainly applied the Doctrine of Discovery and tried to stop the colonists, like George Washington, that scallywag, from crossing the Allegheny and Appalachians to survey land in the West and to secretly, surreptitiously buy it from native peoples. They were doing the same thing Johnson's grandfather was doing. And this case tells us ultimately it was all illegal under international law and under the laws the United States adopted it. So George Washington lost a lot of money. So what were my wife and I Googling today? I thought this part of West Virginia was probably west of the crest of the Alleghenies. I guess you're in the Appalachians, but I guess you're in the middle of it, right? So we'll see if the Royal Proclamation of 1763 applied here. Now that proclamation still applies in Canada, and it's the foundation of First Nations law up there. For us, it's just our history of how England applied the doctrine. So what did the doctrine mean? What does Johnson v. McIntosh hold? Tribes immediately lost some of their land rights when Europeans showed up. Now, I usually pick someone in the front row, sir. See what happens when you sit in the front row?
Wait.
Oh, you're going to enjoy it, and then you can interact with me, and then we can fist fight at the end. So what this case is about is where Europeans showed up with their flag and their cross. What do we all know about that? What do we think about that? We see paintings of Columbus walking ashore in what's now San Salvador and wherever else he landed. And the French, Lafayette, all these people, flag and cross. Oh, they just were thanking God for a safe voyage. That's what the captions of the paintings always say. Wrong. They were making legal claims to the land, legal rights over the people, colonialism, empire. So I'm going to come to your house today with the Bob Miller flag. And what is your address, sir? Can I? And the Bob Miller religious symbol, and then I'm going to claim my house because I'm superior to you. Well, clearly I am because I'm an Oregonian and you're a West Virginian. Come on, of course. I'm a law professor. Yeah, whatever BS I want to make up that I'm superior. And that's what really this claim was about. Now, I jumped ahead of myself about the U.S. putting their flag on the moon. Do you folks know that Russia has been disputing for now almost 2 decades that it owns the North Pole land? Do you know why? 25% of the Earth's known oil and gas reserves are under the North Pole. So Russia has litigated through the UN under something called the CLOS, the Convention on the Law of the Sea. Russia lost that argument that it had a right. But who's going to drill there? Do you know what Russia did on August the 2nd, 2007? I bet you can guess already. They sent a submarine 2 miles below the surface, and with a mechanical arm, they stuck a titanium Russian flag at the bottom of the North Pole. Now, the Danish minister made a joke. The Danish foreign minister said, this isn't the 15th century. You can't go around the world sticking your flag in things and claiming it. I'm coming to your house tonight. Do you folks know what China did? Do you know the big controversy that's going on in the South China Sea?
They built that.
My talk is over. Thank you very much. You're going to see that very point and why China's doing that in just a few moments. So keep that thought in mind. China sent a submarine in August of 2010 to the bottom of the South China Sea. The Chinese flag is at the bottom of the South. Now, today we'd kind of laugh. Well, I could have done that with my GPS, whoop-de-doo. But that was symbolic. It was symbolism of how we always did it. And what Johnson v. McIntosh said is American law. And what he just said, China is building up islands now by dumping sand on little submerged atolls. Vietnam, the Philippines, who else is around there? Japan, they're contesting China's claim to own the entire South China Sea. So what did tribes lose? This case is still the law to this day, folks. Have you ever heard the phrase trust lands? I don't know how much you know about Indian law, but most tribes' reservations are held by the tribe in common, but in trust with the United States. Individual Indian owns that were granted under the Allotment Act of 1887, the Indian individual owns the land in trust with the United States. The United States is the legal owner. So the tribe is called the beneficial owner. The United States is the legal owner. The tribe can neither sell, lease, nor develop their lands without the permission of the United States because they're the legal owner. Individual Indians who own what I called allotments from the 1887 Allotment Act, which is 11 million acres in the lower 48 states, the individual family is the beneficial owner. The United States is the legal owner. That individual family can't build a house, can't dig a sewer line without the permission of the Secretary of Interior. So you think, why did they make such a big deal about this case in Indian law? Because it is a big deal, and it's still the law today. Okay, what else? And this is what Chief Justice John Marshall wrote in 1823. And he based it on European law of colonization, what we're going to talk about in a moment, if I ever get to it. Tribes also somehow magically lost some of their sovereign powers when a European or later an American showed up with the flag and the cross. As Lewis and Clark crossed the country and were branding things with the Lewis and Clark branding iron, what were Lewis and Clark telling all the tribal leaders they met with? If you read the journals very carefully, they held over 50 2-, 3-, and 4-day conferences with tribal leaders all the way across the continent. Thousands of tribal peoples. And they showed him pictures of Jefferson and they said, here is your new great father. The French and the Spanish and the English are gone and will never return. You're now under the governance of the United States. Now remember, Lewis and Clark left D.C. in 1803, didn't return to 1806, 20 years before Johnson v. McIntosh. But they already knew this international law principle and were using it. And here's where I want to get to Jefferson very briefly. Thomas Jefferson, you must remember, was a lawyer. He practiced law full time from 1767 to 1774. And you can read 2 books that analyzed his legal practice and of the 964 cases he handled in those 7 years. Half of them were land cases, were land disputes about who owned land under Virginia law, under Virginia colonial law, and under English law. So Jefferson knew everything about this case 20 years before it happened. And when he sent Lewis and Clark forth, he targeted them at the Columbia River, which I'm getting ahead of myself. Maybe I should have notes and should follow an outline. Oh, this is my outline. Okay, so keep this in mind. These points, this is what happened to Indian peoples, and this is still where we are today. Tribal nations are called the ward, and the United States is our guardian. In an 1831 case also written by Johnson v. McIntosh, Cherokee Nation versus Georgia. That's the second great case of the Marshall Trilogy. So what is the Doctrine of Discovery? So I got involved with the Lewis and Clark expedition in 2003 when my tribe appointed me to be their representative. It's kind of funny how this happened. The chief calls me on the phone. I was an untenured professor. And he goes, we'd like to appoint you as the Eastern Shawnee representative to the Lewis and Clark Bicentennial Commission. And I go, Eric, I was a law professor, not a history professor, and I was untenured. And so I told him, I can't do that. This is not law. I got to write about law. But I thought about this a couple days, and I go, 200-year anniversary. I am not going to be here for the 300-year anniversary. This could be a lot of fun. And it was a lot of fun. So I called my chief back a few days later. Have you guys appointed someone? So I took a chance because I knew Johnson v. McIntosh. But at that time, I didn't know much about Jefferson. Probably didn't even know he was a lawyer at that time. But that's 20 years in advance. He sent Lewis and Clark across the continent. But he was doing these very things when they crossed into what's now called the Oregon Country. The Pacific Northwest. Okay, so I took a chance. I had a ton of fun. I wrote my first book on the topic, and I got tenure. Okay, it's a good thing. But anyway, after reading Johnson v. McIntosh, it seems like 30 times, I was looking for Chief Justice Marshall's underlying justifications for these kind of audacious ideas. Same as me, come into your house, I'm going to claim I'm superior to you, I'm going to control what you do, you and your family, who you leave your money to, everything. Come on, this is insanity. And I'm the legal owner of your house, you are only the benefit. It's insanity. So I read the case over and over. First discovery was absolutely crucial to Europeans. Who arrived where first? That's what the flag and the cross is about. But that doesn't leave much proof, does it? You take your flag across a way and you get back on the ship, the next wave wipes out where you had been. Do you know what Europeans started doing? They started making metal plates. My wife and I were in the Rijksmuseum in Amsterdam, and I missed it. We walked by and Molly goes, come here, look at this. It was a plate from 1616 that the Dutch had planted on the northwest side of Australia saying, we found this first, this is ours. But here's what Elizabeth I and her lawyers did in the late 1500s. She wrote letters. She had her foreign ministers write letters to the foreign ministers of France, of Spain, and England. We don't care if you found something first. If you haven't actually built a fort there, a town, you don't have soldiers and people there, we think it's available for us, the English. So the English were a little late to the colonial game, and they didn't want the Spanish and the French to claim, oh, we saw everything first, it's all ours. We put our flag and our cross there once. So she came up with the idea, you have to actually be in occupation when we, the English, show up. And I'll show you a tiny bit of language I think I have from her grandfather, Henry VII, when he authorized John Cabot to explore the east coast of what's now Canada, Newfoundland, maybe as far south as Virginia. It's not certain how far south. Every couple hundred miles, he'd send his men ashore, doot, this is ours, we'll be back. What chutzpah. But anyway, Elizabeth I contributed to this emerging international law of colonialism and how Europeans could claim, they thought validly, colonial empires. Preemption, what title did the Europeans acquire just by showing up? I'm not going to spend much time on that. Native title. The Supreme Court, I've done the research, they only use the word Indian title 4 times. The lower federal courts use that phrase many times. What ownership right did indigenous nations and indigenous peoples still have after a European showed up? Well, you already are experts on this, aren't you? A limited right. The right to live on the land and use it as long as they still existed or hadn't moved away or the U.S. hadn't killed them all. We already mentioned tribes lost sovereign and commercial rights. Tribes are only supposed to deal with the United States. Indian nations cannot sign treaties with foreign countries. Indian nations are not supposed to trade with foreign countries. They're supposed to deal only with the United States. Jefferson used an interesting phrase in 1792. As you no doubt know, he was our first Secretary of State under George Washington. He had a very interesting debate with the British ambassador about the Hudson's Bay Company still engaged in commercial activities and taking beaver, etc., south of the Great Lakes. So Jefferson meets with Sir George Hammond. What a good lawyer Jefferson was. He writes in advance what he's going to say. He meets with Sir George Hammond, and then he writes him a letter. Lawyers always do that. Write a letter back saying, here's what we talked about. And he wrote notes in his own file the moment he got back in his office. Here's what I did say to Sir George Hammond. Man, God, I wish I was that good of a lawyer. But anyway, now where was I going with all that? Oh, he used the phrase, the Hudson Bay Company, you can't be south of the Great Lakes. He said, those are our Indians. Wow. Okay. Contiguity, I'll show you a map in a moment. When a European showed up, or an American later, with a flag and a cross, how big of an area did they claim? The finding of the mouth of a river allegedly gave this country a claim to the entire drainage system. Think about what the Louisiana Territory looks like, folks. I'm going to show you a map in just a second so you don't have... What is the Louisiana Territory? And then where we're from, what's the Oregon country? What were the boundaries? That's the provision. Now, these provisions, I think I said this at first, I divined these 30 elements of the Doctrine of Discovery. In the law, we talk about elements, the factors that make up a crime or a tort. What are the actual factors that make it up? And so this is just by reading the case so many times, these are the excuses or justifications, whatever word you want to use, that Marshall relied on to adopt this international law and make it American law. Terra nullius, Latin for empty earth. Some of this stuff is just property law, folks. As little kids, we knew this, didn't we? Finders, keepers, losers, weepers. And what other saying did you know when you were 5 years old? Possession is 9/10 of the law. You knew that, didn't you, when you were 5? So look how ingrained some of these ideas are just in law in general. But if land is truly empty, you land on an island and there is not a human being there, I guess it makes some sense to say that's now mine. So see why I'm doing this while you two are here at this meeting? They're taking your house right now. It's empty. We saw no humans. What's hilarious about this is that England claimed Australia for about 160 years, saying that the entire continent was empty. Even though, if you know anything about James Cook, when he landed first in Australia in April of 1770, he was very close to modern-day Sydney. And he had to leave pretty quickly because the Aborigines were throwing spears at him. And yet England claimed it was empty of people, and so they owned it. The Australian Supreme Court reversed this in the Mabo case in 1992 in a stunning decision, saying that was a lie then, it's a lie today, and our law cannot perpetuate a lie. So they've been undergoing massive change in title and giving land titles to Aboriginal groups around the country. I just wrote an article with an Australian professor, and we compared what the U.S. has done to sort of ameliorate for colonialism compared to what Australia is doing. Something like 40% of Australia now has some sort of native Aboriginal land title to it. That's stunning. In the lower 48 states, folks, American Indian tribes own 1% of the land. So we have things to think about and a little ways to go. Okay, my 3 C's, I'll go quickly. He talked about what conquests mean. Military conquest, of course, passes property rights. King A beats Queen B. King A takes over all the properties that Queen B owned. But in international law, the law of war, which also developed around the same time as the Doctrine of Discovery in the 1400s, under the European law of war, King A did not take the private property rights of the citizens of Queen B. They just absorbed them now as citizens of King A. That didn't happen for Native peoples. American Indians lost all their rights to the Johnson v. McIntosh idea. Christianity, do I need to belabor that for a second, that's always been one of the excuses for Europeans colonizing pagans, heathens, savages, whatever name. And civilization has always been used. Oh, these are uncivilized peoples. We got to make them look like Europeans. My mom went to Indian boarding school, kindergarten through the 9th grade, and that's one of the primary goals that Indian boarding school was about, was to civilize. Now, the side goal was to turn the girls into domestic household help and the boys into farming help for farmers. Saw a question?
Sort of where she went.
My mom went to the Seneca Indian School in northeastern Oklahoma. Now, you've heard lots of bad things about boarding school. My mom never had a bad thing to say about it. She was from such a poor family, deceased mother, crippled father. She just didn't tell us that much about it. So maybe she was hiding something she didn't tell us, but she never said a bad thing about it. She had food and a warm place and education. So I think for her, but for many Native peoples, it was a horrific experience. I want to talk to you about how it developed. The Church, Spain, and Portugal developed this international law. Have you ever thought, what is international law? It's the rules that countries agree to comply with in their interactions with each other. That's all international law really is, and it's often just sort of a voluntary thing. If a country like Russia or Germany under Hitler, if they want to do something else, they do it, right? But where did this come from? Well, it came from when Portugal and Spain began fighting over the Canary Islands. They discovered the Canary Islands, they wanted it as empire, and who do you turn to in 1436? You turn to the Pope. And so King Duarte of Portugal makes a very good argument, and he tells Eugenius II, he says, Pope, if you grant me the Canary Islands, I will convert these people, and I will make Catholics out of them. Now, if you're a pope, what do you say? Good idea. Oh, I shouldn't have done that. It was automatic reflex. So a papal bull, do you know what papal bulls are? They're the edicts of the Pope. And he granted the Canary Islands to Portugal, excluded Spain completely. Now, in subsequent decades, now this may be news to you, but Spain and Portugal were like leading the world in technology of building the kind of ships to sail out of the sight of lands. And those Portuguese caravels, they were able to do exploring like no other European country had done. So they're then going down the west coast of Africa too. And what do they want? They turn to the Pope, give us this area too. So the Pope Nicholas V issued papal bulls in 1452, 53, and 55. And I think I'm giving you the language from 1455 here. And here's what the Pope ordered and granted under the authority of God for Portugal to do in West Africa. And then, every European country participated, but I do think the Portuguese were the first and made a lot of money. And here, across the soil, the Portuguese, where they went, they put up stone monuments called padroas in the shape of a cross, and it said on it, this land belongs to whatever the current king's name was. So they were going around the world doing this, but they were smarter than just a flag and a cross. They were building stone monuments, and there still are some of these. Russia, folks, another article I wrote, Russia coming down south of Africa south of Alaska would plant bronze plates in the ground. They had 30 numbered bronze plates saying, we're the Russians, we were here first, this belongs to us. So all these countries learned what those 10 elements were, and if they wanted the rest of the world to recognize their claims, they had to follow certain procedures. And so China sticks its flag on the South China Sea, Russia, and our flag's on the moon. If there had been oil on the moon, we would have a pipeline by now. I don't know how you do it, but we'd have a pipeline. So Spain's cut out of all of this, and they are, to use a legal term, pissed. So, what did you learn in school about Columbus? Oh, he was going west to find a good price on cinnamon and cardamom, and there's another legal phrase for that. That's BS. Columbus signed 7 contracts with Isabella, Queen Isabella, and King Ferdinand. Spices, etc., are only mentioned in the 7th contract. In the other contracts, it's about find us new land. And I can quote you this. They promised him, it's a quote, we will make you the admiral over any land you acquire for us, period, close quote. So when Columbus finds he lands on only 2 islands his first trip, he kidnaps a couple of people, he grabs some plants and whatever, and what's important is getting back to Spain and making a claim to now European Spanish Empire because they now discovered something for the first time. First discovery. And so Pope Alexander VI, who just happens to be a Borgia and just happens to be a Spaniard, put in his position by Isabella and Ferdinand, he issues some papal bulls now, very parallel to the ones that Portugal had been getting for several decades. And look at the elements of the Doctrine of Discovery that I gave you. Find new discoveries, first discoveries, undiscovered by others. I have a little joke there. Natives, well, of course, natives were living there already, but they didn't count. Not even maybe considered human beings. But it belonged to Spain. Also granting Spain's, look at this, if they were not previously possessed by any other Christian owner. So the race is on to get around the world and do that thing first. And if you believe Elizabeth I, you better be building forts and towns and getting your settlers and your soldiers there. Alexander VI issued 3 papal bulls in 1493. I didn't quite finish. The moment Columbus returns to Spain and says, I found new lands, Isabella and Ferdinand send their good guys, the lawyers that is, to the Pope. That was supposed to be a lawyer joke, folks. Aren't we lawyers hated? Until you need one. Right. And so Pope Alexander VI issues 3 papal bulls in 1493. But this line, folks, if you do much reading in international history, you'll see a reference to the line of demarcation. First time I read it, never heard of it. The line of demarcation is this line that Alexander VI drew for Spanish and Portuguese empire. Now look at that map. Now they only knew about the Atlantic in 1493, so the dotted line is the line that Pope... And folks, what else did you learn in school? The earth was flat and Columbus was going to sail off the edge? I'm afraid that's BS too, because the Pope knew about the North and the South Pole. Look at that. He drew a line from the pole to the pole. So I don't know what we're taught in school. Anyway, that's why you need to buy my book, to read the true story. Okay, Portugal refused to comply with that dotted line. Now, there's 2 very good reasons. One, to get around the south of Africa, the Portuguese caravels had to sail well out into the Atlantic to catch the trade winds to whip around Africa. And so they said, we cannot live with this line here. They also assumed there were lands to the west. I mean, Columbus had just found some, right? And so they demanded the line be moved 500 miles further west. And so Spain and Portugal held a treaty in a Spanish town called Tordesillas the next year, and they agreed to that bold red line. And that's what international history calls the line of demarcation. Now, I've answered your question, right? Why do they speak Portuguese in Brazil? Why was that colonized by Brazil? Brazil didn't really colonize too much. Now, Brazil is much bigger today, isn't it, than that little piece? Because of contiguity, because of the river systems. And that element I gave you that Johnson v. McIntosh repeated and that Thomas Jefferson worshipped. Okay, so remember that. So after Magellan crosses South America, Spain claims the entire Pacific Ocean. When Balboa crosses the Panama in 1513, he wades into the surf, does this, claims the entire ocean. He doesn't know it's 5,000 miles across. He doesn't care. But he claims it all for Spain, and Spain wanted no one else being there. Portugal and Spain argue about this, and in 1529 they sign a treaty at another Spanish town of Zaragoza, and they draw the line like this, cutting Australia in half. Do you know that for about 80 years, the English really only claimed the eastern part? And remember what I said, the Dutch had landed in this area and planted those pewter plates with writing on it. So everybody used this doctrine of discovery because it was in their benefit. What if you and I decide to divide his house up and then we fight together? And so maybe we're stronger than this couple, right? And so that's a pretty good idea, don't you? You take the first floor, I'll take the second, okay? Sounds good to me. What do you two do? I don't know. Okay, so England. England came late to the game. I've already mentioned some of these dates. Henry VII, the grandfather of Elizabeth I, authorizes the Cabots go where no Christian, I have the language. And now very relevant to this colony and this state. James I starts chartering the colonies and granting them rights to just take the land and bases it on religion and, yes, contiguity. Elizabeth and Henry based it on go where no other Christian prince has yet been and acquire from me sovereignty, jurisdiction, and title. That's a quote from some of the Elizabeth I charters to Sir Walter Raleigh and Sir Humphrey Gilbert. Didn't they start a colony on Roanoke Island, which I believe is in Virginia, and it failed? But then the later colonies became our states. What about the plagues that killed the Indians? 90% of Indians died before they ever even saw an American or a European because of smallpox, influenza, mumps, everything, I guess. And James I even mentioned it. And the English settlers said, this means God's on our side. I think the next quote might give you a chill. And I believe this guy was a minister, wasn't he? John Winthrop was the governor, but I think he was a minister. God hath cleared our title to this place. Okay, move on, Bob. I have to show everyone this. This isn't really relevant. But Americans need to know this. This is one of the uglier letters in American history. It's called the Savage as Wolf letter. So this is just after we signed our treaty with England that settled the Revolutionary War. And our existence as the 13 states, the United States, is now at least guaranteed from England. They're not going to invade us tomorrow. And so the Congress, the Continental Congress, or no, by this time it was the Articles of Confederation Congress, they asked George Washington, what advice do you have about what we should do and how we advance to the West? And here's what George tells the Congress. The Indians will retreat as soon as we are ready to advance upon them, and it's much cheaper to buy the lands than to fight wars for them. We cannot talk about settling the Western country without peace with the Indians. Now, folks, what's he really talking about? Manifest destiny, isn't he? Now, the word manifest destiny and the idea of manifest destiny was not put into the American language until a New York businessman wrote about Texas in July of 1845. And he's the first to use that phrase, it's our American manifest destiny to acquire Texas, because God intended it, and we were there, and he used many of the elements of the Doctrine of Discovery, those 10 I gave you that Johnson v. McIntosh relied on. So Washington is very clear. It's cheaper to buy the land. We're superior to Indians. They're going to disappear. Bye-bye. Now, that's about as ugly. I don't know what word you want to call it. Ethnocentrism, genocide. I don't know what word, ethnic cleansing. But he's analogizing Indians, humans, to wolves and the animals that retreat. That's why historians call this the savage as the wolf letter. But to me, this is the most, both being beasts of prey. So Americans were hunting us. Because what did Americans want? They wanted our land, our resources, and if they could force and enslave us, they'd do that too. It's pretty chilling. And that's the words of the father of our country. Okay, I'll say nothing more. Too much. Okay, does that have anything to do with Doctrine of Discovery? A little bit. But I just can't help not tell Americans a little bit of some of the real history that we should know. Okay, Thomas Jefferson, already said, a lawyer. He knew all about English law and European law. He knew about how they'd colonized this country. And then Alexander Hamilton, if you guys have been to the play, I can't say his name without doing this. I just taught for the first time con law, and in my constitutional law casebook, Hamilton and I'm just bouncing in front of the class. I was in the room when it happened. I hope you've all seen it. But Alexander Hamilton represented the state of New York in a lawsuit against Massachusetts in 1786 about where the border was. And his trial exhibit, which you can look at today in a 3-volume set called The Papers of Alexander Hamilton, he traced the papal bulls that I've talked to you about, and he traced the European arrivals in the New World and the English charters and John Cabot. That was going to be his #1 exhibit at trial. So what to us today is like, what? Doctrine of Discovery? Never heard of it. What are you talking about? We've always owned it all. God meant, can't say that. God meant for us to have it. But our founding fathers knew this in and out. It was the history they had studied at that time. When Marshall writes Johnson v. McIntosh, he's already writing about stuff that's 400 years old. But it's international law. So now today it's 600 years old. Johnson v. McIntosh, still the law in the United States. Still cited by the Supremes and every federal court and state court. Anyway, this is just some of the things that Jefferson understood, the principles, these elements I've mentioned to you of the Doctrine of Discovery. I don't have time to go on anymore, but I did want you to see this map. Look at the Louisiana Territory. What is it? It's the western drainage system of the Mississippi River. Now, Lewis and Clark were not the only expedition we sent out there trying to explore what had just happened. Do you folks know that Jefferson spent the summer of 1804? It's kind of hot in D.C. He goes home to Monticello, uses his own library to try to investigate when the French had found various things, and most importantly, when did the French arrive at the mouth of the Columbia River. You've heard that Jefferson wrote only one book, but he writes a 40-page pamphlet in the summer of 1804 called The Limits and Boundaries of Louisiana. Lewis and Clark are sent up the Missouri. Lieutenant Zebulon Pike is sent up the Mississippi to see how far north it goes, and then Lieutenant Zebulon Pike is sent along the Arkansas to see how far west it goes. And boy, talk about a coincidence, he finds a mountain out there called Pike's Peak. What a coincidence! Do you know that was also a European trait? Name everything. Map everything. How do I now prove where I've been? I don't have GPS then. Lewis and Clark named every river. They named them after their cousins, their sisters, their wives, their kids. Does anybody know Montana at all? There's the Marias River, and that's how everyone says it. But that's wrong. It's Maria's River. William Clark's first cousin, Maria. So they named everything they saw. And then Jefferson sent another expedition that almost no one knows about along the Red River. William Dunbar and somebody Scott were sent. Find out how big the drainage system, the Mississippi is, because that's what the U.S. claimed they had bought. Oregon country, the drainage system of the Columbia River. Most of British Columbia to this day. Now, I always ask you, what was James K. Polk's campaign slogan in 1844? Very good. Who said that? Was that you, ma'am? One person usually knows. Now, do you run for president with a slogan no one knows? So in 1844, everyone knew what he meant. 54-40. He was claiming the entire Oregon country to the 54th degree of parallel. Which, is that latitude or longitude? I'm no expert on this. I think it's latitude, correct? He was claiming all of British Columbia was, we're going to go to war with England. Well, political BS, of course. 2 years after he's president, we signed a treaty with England that draws the line where it is today at the 49th degree of parallel. But anyway, Lewis and Clark built forts. They occupied the forts. This is in modern-day North Dakota, Fort Mandan. This is at the Oregon coast at the mouth of the Columbia River, which is what Jefferson in writing said, go there, stay there. So they lived there. They finished building the fort December of 1805. They left on March the 23rd, 1806. Meriwether Lewis carried a branding iron. It's not mentioned in the journals until they crossed the Rocky Mountains. I got to go back to the map real fast. So we claimed all of this under our 1803 treaty with France. But once Lewis and Clark crossed the Rockies, they knew they were in territory that it wasn't yet settled who owned it. And everyone who wrote a journal, 6 men wrote journals. All we think of is Lewis and Clark, but 4 sergeants wrote journals too. All of those people wrote, we are now leaving the United States. And so now Meriwether Lewis starts using his branding iron. And you can see that branding iron today. So when you guys come to Oregon, come to my house and claim it. Bring your, I'm going to guess your name's Bill. Bring the bill, flag, and cross, and then we can have a discussion. We argued with England for 40 years. We signed a treaty with Russia in 1819, and they withheld their claim to the 53rd degree of parallel in north, just modern-day Alaska. We signed a treaty in 1824 with Spain that they would contain their claims to the 42nd degree of parallel south. That's today's modern boundary of California and Oregon. Some of these boundaries are based. But we in England argued for nearly 40 years over who owned it. We claimed we found it first when an American fur trader sailed in it. Look at the name of his ship. He names the river the Columbia. Jefferson is Secretary of State. Don't forget these dates. Jefferson knew we now had a legal claim to the Pacific Northwest. But what was my second element? We had to get back there in time and actually occupy it. Lewis and Clark, the building of Fort Clatsop. And then John Jacob Astor, the most famous American fur trader, writes a letter to Jefferson in 1808. He says, I'm thinking of building a fur trading post on the Pacific Northwest, maybe at the mouth of the Columbia River. Jefferson, I see him doing cartwheels in the White House. Jefferson writes him back, this is a quote, I will give you all the support the executive can provide. Get out there, man. Build a permanent post. And I got to tell you what the Homer Simpson moment of all this is. The Hudson Bay Company and other English fur trading companies, they'd been expanding their range every summer across Canada. In June of 1811, Hudson Bay Company guys are canoeing down the Columbia. They can hear the ocean. They now know they've made it across the continent, and they're going to claim all this for England. And they look up on the hill, and there's Fort Astoria with the American flag. And they all went, doe. Homer Simpson. Oh, well, here's the most important parts. Here's my first book. That's in paperback. You can buy that on Amazon. And then I wrote a book with indigenous scholars from Canada, Australia, and New Zealand. And we wrote this book about how England and we as English colonies used the Doctrine of Discovery. And this painting, I couldn't get it we got this painting from a Canadian First Nations person who let us use it for free. The 3 boats of Columbus. And then what doesn't show is there's a cross stuck in the forehead of this native. This couldn't be a more perfect painting for our book. And this book is not $15 because it's Oxford University Press. I have no control over that. Okay, so now I'm going to talk West Virginia. You guys give me another half hour because it's West Virginia, right? And I can slow down and talk real slow now. I mentioned the Royal Proclamation of 1763. I'm going to show you the language in a moment that King George III knew what it was. He claimed it and used it. This was common knowledge among European powers and the lawyers of the day and practically everyone that this is how you created empire, and colonized. So how good's your history? George Washington causes the French and Indian War. Do you folks know that that was actually a world war that cost England dearly and left the king bankrupt as he fought France in many places around the world? The U.S. was like a backwater theater of what we think's the big deal French and Indian War. Started by George Washington somewhere in Pennsylvania. I've been to the very site where he and Indian troops fired on French troops. So George says, I'm going to tax you guys because you caused me a war that bankrupted me. So we all know about the stamp tax, right, of 1764, and we know that the colonists were furious. But this is something even more important, and it's mentioned by implication in the Declaration of Independence. I'm going to show you that in a moment. And this is very much West Virginia. So the king says, you guys messing with Indians, you guys messing with Indian tribes led me to have a war, and I'm going to stop that. And so he defined Indian territory as all lands west of the Appalachian and Allegheny Mountains. So that's why I was looking up today online where we are. So I guess we're kind of smack dead. Are we at the crest? Are we on the west side of the crest? Does anyone know? Okay, then this royal proclamation absolutely applied to the lands where we are standing right now. And what did George say? None of my subjects can go into that area or can buy lands without the permission of my royal governors, because he didn't want the George Washingtons of the world, and going clear back to Johnson v. McIntosh, the William Johnsons, causing disputes with tribes and causing war that the king then had to pay to settle. So George Washington, all this surveying he was doing, all these other surveyors, if they were crossing the Allegheny and Appalachians, they were trespassing and they were in violation of the Royal Proclamation. And you can read some of this. See if you see some of my Doctrine of Discovery elements here. Now, I helped you by underlining it. I try to be helpful. Now, folks, under our protection, that's sort of the Johnson v. McIntosh idea that you're now subject to us. And the Cherokee Nation versus Georgia case from 1831, that the Indians are the wards and the United States is the guardian. King was talking the same thing. Do not disturb them in the possession. Okay, Indians still had the right to live. What was Indian title? Because I have to speak so fast, I didn't explain that. But Indian title is the right to use and occupy the lands until your whole tribe dies out or you sell it by treaty to the United States. So the king understood the possession of native peoples of their lands, and that's why his subjects shouldn't be out there disturbing them or surveying. George Washington had no business out there surveying Indian lands. But notice this, the king is now claiming his right of preemption, his right to buy in the future. Look at that, he calls it our dominions, although we've not yet purchased it. That's one of my other 10 elements. The European claim or the American claim that this is ours will be back. Reserved to, this is the royal we, the possession not yet been purchased by us, that's the royal we, or reserved to them. The lands were reserved to the king. So this is very much, at least some part of West Virginia, if you're past west of the crest. Now, why am I tying this into the Declaration of Independence? And I'm going to jump ahead, folks, because everyone knows this phrase. What I'm sure here, see, I know you're reading it all now, so stop that. I should have rearranged the order. So in the Declaration, do you remember Jefferson writes that there are many valid reasons we hate the king and we deserve to be free. And he gives a whole laundry list of just horrible things King George III has done. Now, the bottom one is what I wanted to show you. Everyone knows this is in the Declaration of Independence, that somehow it's the king's fault and he's unleashed the merciless Indian savages. Okay, but here is the Royal Proclamation, folks, by implication. And the colonists were furious about this, that they could no longer cross the Alleghenies and Appalachians and buy land from Indians. George Washington, in his personal diary, had a copy of the Royal Proclamation, and he wrote, and I think I can quote this, "This is a temporary expedient to satisfy the minds of the savages," quote unquote. So Washington was well aware of the Royal Proclamation. He was well aware that what he was doing was illegal, and he didn't care. But we then used this as one of the reasons to hate the king and to claim we had the right of independence. And this is only by implication, and I'm making an argument to you that I don't know that I've made this argument in a speech before now, but as I started to think about West Virginia and what could I say that's West Virginia specific, well, I've already showed you the Royal Proclamation, and now here's a reference to the Royal Proclamation in the Declaration of Independence. So there's two references in the Declaration in that laundry list of grievances related to Indian law, Indian peoples. What new conditions did King George III put on appropriating new lands? The Royal Proclamation. And I tie it into my larger talk because it's pretty much based on the Doctrine of Discovery. And in that language, let's see, where was it? There's at least 3 of my elements of the Doctrine of Discovery right there. Okay, now I don't know how to end now that I had my big point. How do I normally end this? Well, thank you for coming. I thought there'd be 2 people here. I emailed Kyle and said, it's dang hot. And then I read today, now it's going to rain. And, in Oregon, we don't go outside. Anyway, I appreciate you being here very much, and I'm looking forward to any questions you might have, and then we got to eat some food, don't we? Okay, thank you. The French fur voyageurs were famous for marrying Indian women. So I don't, you're generalizing about the English. Maybe the English were more racist. I shouldn't use that word.
Well, the Irish were considered savages, so they married.
Do you know, thank you for bringing that up, folks. The only English pope there's ever been issued a royal proclamation in a papal bull in 1100 to colonize the savage Irish people, even though they were Catholics.
No, I don't know if they were Catholics with that.
Yes,
They were, yeah.
I wrote about that in my second book.
Right, yeah.
So that's the only English pope there's ever been. But he goes, yeah, England, he's trying to make the king of England happy. Yeah, go conquer the Irish. They're savages, and yeah, they say they're Catholic, but we don't think it. So the idea, this racism, okay, I guess I've lost your question, but this idea of superiority of one group over another is a part of American history. I don't know how much English intermarried, but the French voyageurs did for sure. Even out in Oregon, there's something called French Prairie. And once they were done working, a lot of them retired there and became farmers so much. And yes, they were married to Indian women. There's a couple tribes in North Dakota. There's several tribes with French names because of so many French intermarriage. I'm blanking. A friend of mine is from Turtle Mountain, Chippewa, and all their last names are French. There's several tribes in Minnesota and stuff. So I can't answer what is perhaps true about the English. I don't know. Let me tell you something, folks, that's shocking. Do you know how we paid our Revolutionary War veterans? We had no cash. We paid them with what were called warrants. We'll give you land in the West if we ever acquire it from the natives. And they knew we were going to because I showed you George Washington. I'm just going clear back to the dumb case. Come on, Bob, hurry up. I'm getting carpal tunnel. Chief Justice John Marshall should not have decided this case. He had been a colonel on George Washington's staff, and he had warrants to 400,000 acres of land in the West. So his decision literally went a long ways to helping him. Now, I've never read that he then acquired title to these lands in the West, but I've read plenty of people criticize him severely for sitting on a case in which he had personal financial interest. His father owned warrants in the West. Thomas Jefferson had, and so every private, captain, lieutenant, we didn't have the cash to pay them. So we said, here, out this in the Ohio country, if it ever becomes a state and the Indians sell us their lands, you will own these. So can you imagine? Now that's brilliant. Send these veteran soldiers to the frontier. So you have a fighting force ready if you need it, who are also greedy as hell because those 10 acres will be mine if we get rid of the Indians. Talk a recipe for what word do you like? Ethnic cleansing, genocide, what do you want to call it? So history is far uglier. History is written by the victor, so the good things are written and not the bad things. Other questions? I have another hour to go. I'm pumped with energy. Okay, thank you very much for being here.